4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Welcome to the studio. Welcome to the microphone, Andrew Bell from Bell and Senior Lawyers.
Thanks for having me back, Colin.
You're very welcome. Well, we will be continuing our conversation on family law that we started last week. But this is your program. This is your opportunity to get a little bit of free legal advice live on air. Maybe you might just want to figure out whether you have got a case or it's worthwhile exploring. Perfect opportunity for you to give us a call this morning. 0755 208888 is the number. We'd love to hear from you. Do not leave it to the end of the program. Now, Andrew, family law, we might do a bit of a summary on what we started in our discussion last week.
We will. We had a great week last week, and we'll remind everyone to call in early because we ran out of time for everyone. But we had started talking about some key terms for family law, and we're focusing on separation. So we covered what is separation, and that's where even if you're living under one roof, you're no longer living as a couple, and that works for married and de facto couples. After 12 months of separation, you can get divorced, married, and then after that, you can do your property separation. If you're getting divorced, you can actually do it before that. Any time after you're separated, you can apply to the courts to do a property separation, and you've got 2 years if you're a de facto. And then we started talking about other concepts like property pools, which is essentially everything the couple owns in their own name or jointly, so we can consider it for a property separation. All
right, well, that's a good basis. We do have our first caller. It is a very good morning to Ross. Ross, ask your question of Andrew.
Oh, okay. Andrew.
Morning, Ross.
Good morning, Andrew. There's a group of us in January this year. We joined a local bowls club.
Mm-hmm.
The fees to join to become a full bowls member was $140, and we were told that we could, if we're in a competition, we have to pay extra. But if we're not in competition, but just having casual bowls there's no other fee.
Mm-hmm.
Now, a couple of weeks ago, the new president was elected, and he decided that no, anyone playing bowls now has to pay an extra fee. So they've now said besides our membership of $140, we've now got to pay $5 for every game that we play.
So you said that there's a new president that's been elected. I take it there was an AGM where that president was elected?
I'm not quite sure. He just introduced me. He said, Ross, he said, I'm the new president of the club, and we're going to introduce these fees now for you and similar players.
Okay, well, normally clubs operate on a financial year basis, and then they have an annual general meeting where they need to re-elect the members, and those members in the management committee or the board, whatever they're called, have the power to set the fees for the next year. And normally the fees need to be tabled at a meeting of that management committee. Now, there will be a club constitution that will give people different powers to do different bits and pieces, and if you're a member, you're within your rights to get a copy of that constitution and a copy of the rights to get the minutes from any of those meetings. Now, while I can understand you're annoyed that they're now charging you fees, that is something that the clubs have the power to change from time to time if they've done it properly. So I would advise that you check to make sure that they've done it properly, or ask the secretary of the club what grounds are these fees being introduced. Legally, if they've done it properly, I don't think there's much you can do to challenge it.
Even though it's halfway through the year, it's halfway through the year.
Well, when are the membership fees due? Like normally they rotate.
It's calendar year.
It's calendar year.
We joined up in January.
Okay, well, I would definitely be asking them the basis that they're increasing the fees because, but they may have an extraordinary reason to do that, and they probably have the power to do that.
The basic preface, Ross, is that the board manage the club or the not-for-profit on behalf of the membership. So you have the rights to have a look at the Constitution. You have the right to examine decisions, but again, they're managing it on behalf.
Yeah. So it's not like a traditional contract. So
okay, all right. Another question.
Yep.
I've written a song,
mm-hmm.
and I'm just wondering what's the most economical or safest way that if I was to send that song to someone, maybe a publisher or whoever, a singer, and they decided to, record it, how can I get protection for my rights in that song?
So in Australia, copyright automatically vests at the moment of creation. So if you're the author of the song, then you already own the copyright and you don't need to register it.
Look, we do a lot with that here, Ross, and we get this question most often. I can tell you the cheapest and easiest way to protect your rights and not fall into an argument to say, hey, I wrote it, no, I wrote it, no, I wrote it, is you take those lyrics, you write, you either print them out and then sign it and date them, you put them in a registered letter and you send it to yourself. You do not open that letter and you put it in a safe. And at the end of the day, if there's ever an argument over the lyrics, you can produce the letter, take it to a solicitor, and he can say, well, there you go.
Absolutely. Great advice.
All right, Andrew, appreciate your help. Thank you for that. Thank you.
No worries.
All right. Well, they were two very diverse questions, and there you go. Great example of what you could ask this morning. 0755 208888 is the number to call, and pose your question to Andrew. Get a little bit of free legal advice. Well, we are talking family law this morning. It doesn't mean you have to pose your question on family law. So the next question on the docket is, are the rules the same for married and de facto couples?
So, in the past, if you're a de facto couple or a common law wife, as some people, a common law relationship, as some people might refer to them as, there used to be different rules. Then at some point, each individual state had different rules about de facto relationships. But since 2009, the property division framework is largely identical for both. There's some different sections under the Act, and there's those different timelines I mentioned before. 2 years after separation for de facto is your timeline to separate property. But practically, all of the same law, regulations, etc., are applied the same way if you end a de facto relationship or if you end a married relationship. And if I bring you back to what a de facto relationship was, it's in a committed domestic relationship for at least 2 years.
Okay, so that's an interesting one. So one you get documentation to say that you are married, and one you're making a statement to say, hey, we've been together for a while and we are partners. And do you ever get into a situation where one partner or one person argues the toss with the other?
Absolutely. It's very common. Particularly people will say, oh no, our relationship ended well before, so that 2-year period is up. Or they may say that they never intended to be in a relationship. And it is actually very difficult, particularly if people have separate houses. They can still be in a de facto relationship, depending on how they're living. If there's children, there could be children that's part of a relationship or part of an encounter. And did that create a de facto relationship? So it's not uncommon for one party who wants the property divided in their favour to allege that there's a de facto relationship while the other one denies it ever existed. So then they need to take into account witness statements and bank statements and all sorts of other bits and pieces where it's much clearer you intended to be in a relationship if you're married because you got that certificate. Yeah,
wow. Okay, so it can get... This is why we need these rules and regulations and how the waters can be muddied. BFA, Binding Financial Arrangements. Most people call these prenups. What are they and when do they hold up?
Okay, so a binding financial agreement is a type essentially of a contract between two parties that sets up how property will be divided if a relationship ends, or it can be created by two parties after the relationship ends, or at any time during the relationship. So they can be made before, after, or during a relationship. And to be binding, both sides need to have received independent legal advice. They need an independent lawyer's certificate to say that it's actually been explained to them, that they're not under any sort of duress, because these are common things that people complain about. Oh, I didn't know what I was signing. I didn't mean to sign it. And then there needs to be what we call full and frank financial disclosure. So each side's financial position needs to be very clear to the other side when they're going into signing this BFA. However, and if it's not, then they can challenge it afterwards. So if someone had a couple of $1 million or an extra property that they didn't declare, and someone signed a document, and then they later find that the other person was wealthier than they thought, then they can come back and challenge it and say, well, the BFA wasn't binding because they didn't give me disclosure. Now, most of the time, the BFA will stand. They're actually pretty good law in Australia. They will get set aside for the court for fraud. In the non-disclosure of assets that I just mentioned, duress, so there was a lot of pressure, undue pressure put on one of the party, unconscionable conduct, so someone was tricked, or where circumstances changed so significantly that enforcing it would be unjust. And the most common example of that is where children arrived after signing the BFA and it wasn't contemplated as part of the BFA that they signed and got themselves into.
Okay, so it can get very complex indeed. But look, sounds like the laws are a lot different to what we see on the television.
They are. They've evolved a lot. We've got the no-fault divorce that we covered in previous things, so you don't need to allege that someone did something wrong, and it's just about what property exists and how does it get divided up.
All right, this is your program, your opportunity to get a little bit of free legal advice this morning. All you need to do is give us a call on 0755 208888, and we might go to a caller now. It is a very good morning to Rod. Rod, ask your question of Andrew.
Yeah, happy Tuesday to you both. Andrew, I just had a meeting with estate agents yesterday, and I asked them if they would mind auctioning our home.
Okay.
And they informed me, I'm an old-timer, and they informed me, well, you've got all these documents you've got to do now, Form 2s, bankruptcy, money laundering, et cetera, building and pest, so on and so on.
Yep.
And I said, well, I'm not doing, and that's going to cost you X amount of dollars. I said, look, the reason I want to auction it is buyer beware, you do your own homework. I'm not doing it.
Okay,
what are the consequences?
Keep going.
What are the consequences if I don't do it?
Okay, well, anti-money laundering laws came in last week that apply to real estate agents, accountants and lawyers, and pretty much they can get fined if they don't understand the source of funds and who they're selling things from. So you will have to verify your identity, and they may ask you for some bank information. If you don't provide that, they could be held liable by AUSTRAC. So they won't even take you on if you won't do their anti-money laundering process. So you'll have an issue there. The Form 2 that we're talking about is disclosure that came in August last year. So that's a form that you give to prospective buyers that says these are the things that are happening with the property. Now, if you do not have a Form 2, they can cancel purchasing the property, or if the Form 2 is incorrect, at any point in time. So if you don't have a Form 2, you could find yourself holding the auction and then potentially not being able to sell it because they've pulled out, and they've got every right to pull out. And you still may be out for the commission to the real estate agent if it's because you didn't have a Form 2. So unfortunately, I'd advise you to do the Form 2. Now, building and pest before the auction, I can't give you a concrete answer whether that must be done. It's normally done. Usual practice is that it's done and available to the people who turn up to the auction, and part of that is so people are fully informed, so they can't come back on you later and say, well, I wouldn't have entered into this arrangement had I been aware of what was going on. Or you may then need to make it available for other people to do. The other thing with the anti-money laundering is every person who's bidding at an auction as of this week also needs to confirm their identity and source of funds before the auctioneer will let them bid on the auction. So yes, there's lots more paperwork than used to be there. But unfortunately, you probably need to comply, and I'd be surprised if any real estate agent would take you on without doing those things.
Okay. So the old days, when I say the old days, we can go back 2 years or 50 years. The old days of a buyer coming up and showing good faith and doing his own building and pest, that no longer exists.
Well, building and pest, I believe you could still probably do that if you made the property available for certain times for inspection before the auction. But I'm not 100% on that. But the Form 2, definitely would recommend you do the AUSTRAC anti-money laundering stuff. I don't think you're going to get away from not doing that.
Well done. Well, I hope the question and the answer helps most of the listeners, because beware, if you're going to sell, you've got all this ahead of you.
Yeah,
okay. Andrew Cole, thank you so much for that.
Thank you, Rod. Happy Tuesday.
Good on you, Rod. Well,
happy Tuesday. Right. Yeah, thanks. Bye.
Bye. Well, yes, there is now a lot more involved. All right, we're moving right along to Mary. Mary, ask your question of Andrew.
Yes, good morning.
Morning.
My 95-year-old friend was invited to move in with his widowed daughter. After a couple of years living together, she got in a de facto partner. Recently, she died in a car accident.
Mm-hmm.
What happens to the property?
Was there a will?
Has the partner got any hold over it?
So how long were they in the de facto relationship for?
I'm not quite sure, but I think it's more than 2 years.
Okay, well, they would. So if there was a will, the will would get distributed according to the will unless someone challenged it. The person who could challenge it on the basis that they needed support from the person would be children, parents, and de facto or married partners, and anyone else who was financially dependent on the deceased. So if they were in a genuine de facto relationship and this person needed financial support and felt they weren't adequately cared for under the will, then they would have the grounds to challenge the will.
Even though her father is 95 years old and dependent on her?
Is this your 95-year-old deceased friend's de facto partner, or is this the de facto partner of her child that she was living in the house of?
The de facto of the widower, of the deceased person.
No, they would have standing to claim.
They have strong grounds to claim?
Well, you'd need to go into the circumstances. If they were independently financially wealthy and they weren't dependent on your 95-year-old friend, then the court may decide that they don't need extra support and they were adequately provided for under the will. If they're destitute and need a place to stay and your 95-year-old friend had funds and they were in a committed de facto relationship.
No. My 95-year-old friend is the father of the person who died, of the deceased.
Oh, okay.
And the deceased has a de facto.
Right, and yet the question is about the father's claim, or is the...
That's right.
Yeah, okay.
We are concerned that he might be kicked out of the house.
Oh, okay, so your 95-year-old friend is living in the house with their child, and the child died but was living with a de facto.
That's
well,
right.
the de facto can claim on the child's estate. They may receive some or all of that estate if they put a claim in. If they're the valid owner of that property, then they may be able to ask the 95-year-old to leave. However, depending on how it was purchased, etc., the 95-year-old may say that they've got a life estate and challenge it the other way. This is getting a very complicated scenario, and I'd suggest that they receive independent advice on this.
Yes, I understand. All right. Thank you so much for that.
Thank you, Mary. All right, and we did have Russell on the phone, but unfortunately that call has dropped out. Russell, if you can hear us, we'd love you to call back in. 6 minutes left in the show. Please do not leave it too much longer. If you'd like to pose a question to Andrew, just like Ross, Rod, Mary have just done, all you need to do is give us a call right now. 0755 208888 is the number, and we'd love to hear from you. Last 6 minutes of the show. Okay, we're moving into the four-step process. We were talking family law. We're moving back into that now. Walk us through what the court actually does when it divides property.
Okay, well, the first thing they do is identify the property pool. So each side, each party needs to disclose their financial arrangements. So every asset, every liability, bank statements, property statements, etc., that needs to get put out on the table. And there are penalties if you don't comply with that. So if you have received proper notification through the court, then you need to start preparing your financial situation. Now, it is private and it is an offence to publish what's gone on in family court proceedings, but you do need to provide, if you're one of the parties, your full financial statements per the current date. The second step after that is then the court will start looking at what they call contributions. So they'll look at what financial assets were brought into the relationship and created during the relationship. They'll look at non-financial contributions. If you built the house or something else, then that might be counted. They'll look at who took on most of the parenting chores or caring arrangements, etc., during the relationship. And after they've assessed those contributions, essentially they will then work out what a split was for what those contributions were. The next step is that they look at people's future needs. So they look at how educated people are, how much people can earn, what their age is, if they've got health issues that are going to need to be done. So any arrangements can make sure that someone's not left out on the street cold destitute while the other person's living in a mansion. And then finally, they'll look at all of those, what the property pool was, how it was contributed to, how they think it should be split, the future needs, and then they will look and see if it's just and equitable. So it needs to be fair to both parties. They won't make a property order unless there's a clear percentage, everything is clear, they don't think that it's unjust, and it adequately reflects the situation that the parties are in.
Fantastic. All right. Well, that seems fairly clear, but I'm sure it could get very muddied once we mire ourselves in it.
We'll go through some scenarios today or next week.
All right. We've got another caller. It is Amanda. Good morning, Amanda. Ask your question of Andrew.
Hi, Andrew. I'm selling a property at the moment in South Australia. Mm-hmm. My question is, though, with the marketing costs, the agent suggested that I sign a pay later loan because the marketing was $5,000 to pay its settlement. But it's looking like the property may not sell and I may have to pay the money out of my own pocket, which I don't have. And I was just reading through the contract, and I've noticed that they've said that I can't rent the property until I pay back the loan. Is that, because I was thinking, well, I would withdraw it from sale and rent the property and then be able to pay them back from the rent. Is that something that they can do?
Well, that is a strange relationship. That's something that I haven't seen. So often they'll defer the marketing costs so you can pay it as part of the settlement and you don't need to pay it. If you've got an exclusive agency with them, then they may say that it can't be rented while they're advertising the property because that may change their marketing or their ability to be able to show people through it. But not being able to rent the property while you're trying to pay it back and it's no longer for sale, that doesn't sound quite right to me. Now, there hasn't the last couple of years been talk of unconscionable conduct and unconscionable contracts, in which case that they're barred from enforcing unfair terms. This would start to edge on an unfair term. If you have no way of paying them back, but renting it would mean that they would pay back, I would start to think that that's an unfair term. If you were looking at taking it off the market and renting it so you could pay them back, my first step would be to tell them that that's what you're planning on doing and then see their response. And if they do say, no, you can't do anything with it, I'd be asking why, and then potentially taking that to fair trading or the ACCC or speaking to a lawyer about it, because they may tell you just to rent it out anyway and see if they're going to enforce it. But I can't give you that definitively without being able to see the contract.
Okay. Yeah, because part of the contract they've also said that they've got a security over my property until I pay back the debt.
That would be correct, yes. So if eventually it doesn't get paid, then they'd be able to sell your property to redeem it, which ironically is what you wanted them to do in the first place.
Exactly. Yeah, all right. So you think it's not really
It doesn't sound quite right from what you've described to me,
Yeah.
but as I said, I would write to them and tell them that that's your intention and that's the only way they're going to be able to get paid back. And if they dispute that, then I'd be looking at the reason why and making sure that's in the contract itself.
Because at the moment, I believe if I take it off the sale, that the amount of money is due within 14 days.
If you end the exclusive period early, then it would trigger the debt to be paid early. So I wouldn't recommend that you end the exclusive agency period. But once that's run out, if they haven't been able to sell it, it feels very unfair of them blocking you to have any sort of way of paying back, given you the only reason you entered in the contract was for them to be able to market and sell the property.
Yeah, because the initial contract allowed me 6 months to pay it back if it's sold. So,
Amanda, we're backing up on local news, and we've got one more caller. So hopefully that's answered your question.
Yep. Thank you.
Thank you.
Very much.
All right, and we'll move quickly on to John. John, ask your question of... Oh, sorry, Joan, ask your question of Andrew. My apologies.
That's okay. Hi, Andrew.
Hi, Joan.
I have a young brother
Mm-hmm.
who needs to go into care. He doesn't have the power of attorney. I'm his next kin. Can I answer things on his behalf?
Well, you could answer things, but you couldn't enter into legal agreements, etc., on his behalf without being a power of attorney or a guardian. Does he have capacity? Like, is he able to sign a power of attorney document? Would he understand what's going on, or is he not able to do that?
No, I don't think would be able to do that.
Okay, so the proper process then would you'd apply to QCAT to be his guardian and get a copy of his medical records and go to QCAT and say that he needs someone to be able to make these decisions for him and apply to QCAT. And I believe you can get a fee waiver for doing that, and the information's on the QCAT website on how to apply for guardianship.
Okay, even though he's in hospital,
Yes.
and he's been there for a month that we didn't know of, I still can't ask them to do...
Well, you can ask things, but it's not. You don't have any legal force being without a power of attorney. So they can say no or yes or make decisions on his behalf, and if you don't agree with those decisions, unfortunately, there's nothing you can do about it if you don't hold power of attorney or you are not his guardian.
Righto. Thanks a lot, Andrew.
Thank you, Joan.
Thank you, Joan. All right, a great little program, some great information, Andrew. Thank you very much for your company again this morning.
Thank you, Colin. It's great to have the audience participation. I'm really enjoying the varied questions.
Andrew will join us again next Tuesday at 9 a.m, where we will do this all over again, and you can pose your questions. We'll walk through a topic of the day. You can also review a copy of this program on our website, 4crb.com or bellsenior.com.au.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.